Hello everybody. Thank you very much for joining us for this short video where we're going to talk through some trends in antitrust litigation with a particular focus on the UK and Germany. And I am thrilled to be here today with my partner from Frankfurt, Jens, who's going to talk us through some of the developments in Germany recently on this topic. So, without further ado, it's been a pretty interesting time in the UK recently in terms of antitrust litigation. We've had the first substantive judgment in a collective action in Le Paterel, a judgment that was handed down at the end of 2024. And in that case, the claim was rejected by the Competition Appeal Tribunal on the basis that the party who is the defendant, their conduct didn't constitute an abuse of dominance because although the prices that they charged were found to be excessive, they were not unfair, and so they didn't meet the necessary test. So that's a notable, important judgment, and interesting that we've had the first substantive judgment, and more I'm sure will follow soon. However, classes are also starting to see returns through settlements of cases, including a substantial £200 million settlement recently in the collective action brought by Mr. Walter Merricks against MasterCard in respect of interchange fees. So that's a couple of things that have happened in the UK recently and where we've seen some material developments. Jens, what have you been seeing in the market in Germany in recent times?
Yeah, many thanks, Caroline. In Germany, as you know, antitrust litigation is indeed playing also an increasingly prominent role, especially follow-on damage claims continue to dominate the scene. A current trend is the substantial strengthening of the position of especially plaintiffs by our current case law or recent case law of the German Federal Court of Justice. This position has become apparent, especially from a series of decisions by the court in recent years. And especially in this context, I'd like to, let's say, briefly highlight two very recent points that are of particular importance for future antitrust litigation. First point is that the court clarified the zero damage report by the defendant is not sufficient to prove indeed zero damages. From this statement of the court, it's finally concluded that the defendants must additionally present a theory of no harm, which makes it, at least to a certain extent, quite complex, especially in front of courts. The second item I'd like to point out is that the plaintiffs are not obliged to submit an economic expert opinion to the court in order to prove an amount of damage. Estimating the damages, which the courts are entitled to do, at least under German procedural law, is rather the, let's say, original task of the court, or moreover the judge handing down the final judgments. Therefore, the plaintiff satisfies his burden of proof in this context if he just presents all the evidence that is readily accessible to him. And in case of, let's say, lack of evidence, and provided that it is at least established that a damage has occurred to the plaintiffs, the court is obliged to estimate at least a minimum damage, which is, let's say, a very high advantage.
That's fascinating, Jens, and it's a little bit similar in some ways to the approach the English courts have taken, where they've spoken about where there is a lot of complexity in assessing damages, needing to apply, they refer to it as the broad axe, to take a pragmatic view of assessing damages where the evidence is limited for whatever reason. So it seems that the courts have some similar considerations in mind in those sorts of cases. Fantastic, thank you. I mean, one thing that I wanted to ask you about was in the UK, we obviously have this class action process, which requires a class representative to be chosen and then the claim to be certified with that class representative acting on behalf of their class. And what we've seen in the UK recently was the first time where a case did not proceed at that certification stage, because the class representative was not approved by the tribunal. So the tribunal said they weren't a suitable class representative for the case. And that was the Reefer against Apple case. I wondered if you have a certification requirement for class actions in Germany, and does that work in a similar way? Are there challenges around suitability of a class representative, or what sorts of issues does that raise?
Yeah, many thanks. Fantastic question, I'd say. First of all, so class actions similar to those in the UK do not exist in Germany yet. However, the, let's say, successful primary form of enforcing a large number of claims is the assignment model. And in this model, cartel damage claims are simply assigned to a separate litigation vehicle that is finally set up to collect claims for third-party account. And these companies usually take legal action to collect these claims. And the main point of disputes in this specific context was to date often a potential violation of the German Legal Services Act. However, and following the European Court of Justice judgment in the Rundholz-Cartel case, in Germany, it is now up to the German lower courts to analyze whether there are any other individual legal remedies available under German law that comply with the principle of effectiveness.
Fantastic. Thank you, Jens. So I think we've covered a little bit some of the recent developments. I wondered if I could ask you what you think is on the horizon for the coming year or so in terms of where you think things might go next in antitrust litigation in Germany.
So, good question again. So in view of the development of the case law of the Federal Court of Justice as described before, it will now become apparent how the courts of the lower instances in Germany will deal with the defined requirements. It is expected, or overall expected, that the lower courts in Germany will now make more frequent use of their power to estimate damages, thereby making antitrust damages actions more effective in very general. At least one can say that the way has been paved for such an approach, so everybody's waiting on how the courts will be behaving. Other than that, I think the enforcement of the Digital Markets Act should also always be closely monitored because the DMA offers another large field of potential private litigation in Germany, in particular in the event of non-compliance decisions issued by the European Commission. A large number of private lawsuits in this area can be expected, at least that's our view.
That's really interesting. Thanks, Jens. And obviously the DMA is not applicable in the UK, but we have our own DMCCA, which is a slightly different, but also a digital markets regime that's been introduced very recently. And again, it remains to be seen, but how that plays out. But there could well be litigation arising out of that in due course. That's been super helpful. Anything else you want to raise, Jens? Otherwise, I think we'll wrap up there. And thanks everybody for their attention.
Perfect. Many thanks.